Hello, everybody, and welcome to our first lesson in the study of contract law. In this lesson, what we're going to do is take an introduction to the subject of contract law, looking at the importance of it within the general legal system of England and Wales. And then we're also going to outline the structure and the scope for this series in more detail. This is the first lesson in terms of our subject and our study of contract law. We'll take an advanced analysis of the study of contract law in this series of lessons. It's going to be a lot of lessons. We're going to be taking a long time to really get into a lot of detail. And in this lesson specifically, however, we're going to introduce some basic themes and ideas. So essentially defining a contract, looking at the importance of the contract within everyday life, and then talking about the fundamental characteristics of the contract before going on to having a look at the scope of this series of lessons. So ultimately, the question that needs to be asked here is the question of what actually is a contract. Now, one of the things that's quite interesting is, despite the fact that you might not know what a contract is at the moment, contracts are potentially where individuals within society have the greatest interaction with law. So, for example, contracts are made, tens of thousands of contracts are made every single day for all kinds of purposes. So some of these purposes might include very small things, such as the purchase of an item from a shop. They could also include very large things, like the signing of a lease on a property, something that would actually commit you to a significant sum of financial liability, as well as a significant period of time managing and owning, or at least being the leasehold owner of a particular property. So ultimately, the conclusion to this point is that essentially there are tens of thousands of contracts which are formed on a day-to-day basis. And for the most part, there are very few problems with these contracts. Of the tens of thousands of contracts which are formed every single day, some of them being very implicitly established, like, for example, purchasing an item from a shop, some of them being far more formal and substantive, like the signing on a lease on a property, most of them have very little in terms of controversy. But there will be a very small number of these contracts which are challenged or put under scrutiny in a court of law. And this is really where we get our idea of what contract law is essentially getting to the heart of. These difficult issues and these difficult questions relating to the nature of a contract, the enforcement of a contract, bringing a contract to an end, what actually is a contract, all of these different kinds of questions. So, simply put, the most simple way in which we can define what a contract is that a contract is simply just a legally enforceable agreement. This does not tell the whole story, because not all agreements are classed as contractual, because this idea of what is legally enforceable in terms of an agreement is essentially doing quite a lot of heavy lifting in this definition. There are certain formalities and requirements for what essentially creates a contract, one that is actually an actual contract, which is a legally enforceable agreement. So not just all agreements at all can be classed as a contract. So a person that I have an agreement with, if they were to fail with their obligations, that does not automatically mean that I can sue them for breach of contract. The question of whether or not a contract is present requires more than just this simple definition that is stated here. Given the fact that contracts require a number of different elements to be considered binding, we have to then think about, well, what are these different elements which are to be considered binding? So, even though we're going to spend a lot of time examining this in far more detail in future lessons, I will give you right now the essential elements of a contract as defined and as established by just essentially the history of contract law. So the first part of a contract is that in order for a contract to exist, there has to be an agreement. Now, the agreement factor, the part of the contract which is considered to be an agreement, is made up of two distinct elements. You have to have an offer in conjunction with an acceptance of that offer. And in this series of lessons, what we're going to do is, despite the fact that essentially you can't have an agreement without both of these factors. You should we're going to essentially delineate each of these topics separately. So we're going to talk firstly about the concept of an offer. What is an offer? What is the distinction between an offer and, for example, an invitation to treat? What kinds of circumstances do we find an offer? And then we will also talk about what is an acceptance of an offer, what constitutes the acceptance of an offer, how ought acceptance be conveyed to the person who is making said offer. The second part of a contract that is required is this idea known as consideration. Now, consideration essentially just means something for something else. So there has to be some kind of exchange of some kind of value. So if I were to purchase an item from a shop, the reason why that is a contract is because there is consideration. There is the fact that the shop owner is going to get some of my money in return for me getting the item that I want. This is the sort of quid pro quo that exists within all kinds of contractual arrangements. That's what we'll look at in a future set of lessons. We'll talk about what actually it means to have good consideration of in relation to a contract for a contract to exist. There also has to be a combination of certainty and an intention to create legal relations. Remember, from our previous definition, a contract is a legally enforceable agreement. So there has to also be the intention to create legal relations. There has to be this belief that the parties who are entering into this agreement with this consideration, with this offer and the acceptance of the offer, that all of these things together are done under the auspices of this intention to create legal relations. Now, those are the three main requirements or elements of a contract, but there are also other requirements depending on the type of contract which you are signing. So there may also be formality requirements for certain contracts to be valid. So, for example, in certain circumstances, it might be a requirement that a contract be done in writing rather than an oral contract, which is just done via spoken mouth. Now, while this is a necessary requirement for some contracts, it is not a necessary requirement for all contracts. So we would not suggest that the idea of it being in writing or formally enshrined in writing as a condition for contracts as a whole, a necessary condition for contracts as a whole. It might just be a necessary condition for specific contracts of specific types. But we will get to that, and we will get to looking at the distinction that is made between oral contracts, verbal agreements, as well as written-based contracts too. So, given that, let's look at the scope of this series of lessons. What are we actually going to cover, and in what order are we going to cover it? We're going to begin, as you might expect, by talking about the creation of a contract, talking about all of these elements that we see here and what they actually mean, what they actually require, and how people have interpreted them over the years. So we will talk about the nature of an agreement, we will talk about the idea of the offer versus the acceptance, and then we will talk about the subsidiary factors. Subsidiary not implying that they are less important, but just implying that they are not part of the enshrined part of an agreement, for example. So we're going to talk about certainty, intention to create legal relations, and consideration. We'll then also finish this little first topic on the idea of promissory estoppel. The second major topic is going to talk not about where contracts come from, what contracts are and how they are formed, but more the contents of a contract. We will talk about the terms of a contract, talk about the idea of terms and versus representations, talk about this idea of warranties in certain consumer-based contractual arrangements, exclusion clauses and unfair terms. The third section will talk about bringing a contract to an end. The various circumstances whereby a contract may come to an end, including by way of misrepresentation, duress, undue influence, as well as the doctrine of frustration and mistake. In relation to this as well, we will cover very, very briefly the idea of performance, which is, of course, the most common way in which a contract comes to an end. Performance is really where all the parties make a contract, they agree to a contract exists, and then they just perform the terms of their contract. They perform their obligations under the contract, and then once they're done, the contract ends. Of course, that is the most important, or at least the most common way in which a contract would come to an end. Of course, that's not particularly very interesting for lawyers, because we're talking about all of the more messy situations where contracts come to an end, like frustration, mistake, undue influence, and duress. And then finally, we're going to talk about the various different remedies and damages for potential breaches of contract. So we'll talk about what it means to breach a contract, the idea of compensatory damages, liquidation of damages or liquidated damages, limitation of damages, and other remedies which may be available in both law and potential equitable remedies that could exist in relation to contracts being breached. Welcome back, everybody, to Contract Law. What we're going to do in this lesson is talk very briefly about this idea of contractual theory, the classical theory of contract. The idea that essentially is fundamental and permeates all of contract law, and really gives us some of the most fundamental principles of contract law that we will then get into in the next lessons as we start to think about how contracts are formed and the kinds of terms of contracts that exist, etc., etc., etc. So this is going to be some of the theoretical elements behind contract law. We're not going to be spending too much time looking at theory of contract law compared to, for example, the theoretical lessons that we have done on criminal law, which is far more substantive and far more detailed. Instead, what we're going to be doing is talking about the theoretical concepts of contract law, the foundational elements of contractual theory, and then we're going to use that information to take us further into the next few lessons where we start to talk about how contracts are actually made. So the theory of contract opens the door, essentially, to our understanding of how a contract may be formed, and specifically the essential elements of a contract that are required for a contract to essentially exist. So what is the classical theory of contract? Developing from and around the 1700s, we start to see the emergence of a body of law that we would describe today as the law of contract. So the law of contract is relatively recent in terms of its development within English history. At least the principles of contract and the theories of contract law that we know of today. The theory of contract law itself would emerge as we go into the 1800s, and we start to look at some of the early cases in contract law taking place towards the end of the 1800s. You will notice that the theory of contract law is quite deeply enshrined within these different cases because of the development of this theory from the 17 and into the 1800s. In addition to this, we see the imposition of various elements of contract law and contractual theory, and essentially contractual theory hinges on two major elements, two essential elements that exist within a contract that are not necessarily principles of a contract that are necessarily legal principles, but even though they are to an extent, but they're not specifically legal principles. That they are more principles which permeate the essential characteristics of what a contract may be. These are the freedom of contract and the exchange of obligations. These are the two fundamental elements which not only conceptualizes contractual theory, but also conceptualizes contract law. And we will see at multiple stages as being important elements within the framework of a contract. So think about this then. Let's think about these in two details. We'll talk firstly about the freedom of contract. What does this mean? What is the principle of the freedom of contract? Well, the principle of the freedom of contract simply stipulates that an individual is able to enter into a contractual obligation with whomever they so choose, so long as the other parties who are also part of this contract have that same obligation, have that same freedom, shall we say, so long as they are also willing to enter into a contractual arrangement. So early in the 19th century, this was a principle that was recognized by courts, that individuals have the freedom to do whatever they want to enter into a contract and to contract with whomever they please, they so chose. And ultimately, this is a principle which does have its limitations. We will get onto some of the limitations that take place. And in terms of the specific terms of a contract, there are some limitations there as well. But for the most part, if I want to sign a contract and enter into a legally binding agreement with another individual and have whatever terms that we want, so long as there is an exchange of obligations, which is the second principle, then this means, therefore, that I am free to do so. I can do whatever I want, enter into whatever contract I want, and this is part of the general principle of the freedom of contract. So I said as well that in addition to freedom of contract, we also have freedom of contractual terms. There is a very little limitation in terms of the kind of terms that a contract may or may not be allowed to have included within it. There are certain terms that you cannot have in a contract, and we'll get to that when we look at contractual terms. But for the most part, there is little restriction in terms of just ordinary terms which could be part of a contract itself. So you can essentially be freely able to decide what the terms of your contract will be and who you are going to enter into this contract with. In addition to the freedom of contract, we also have this principle known as the equality of obligations, or at least a sharing of obligations. It's the second fundamental principle of contractual theory. And it's the idea that a contract involves not necessarily the equality of obligations, but more acutely and more accurately stated as the exchange of obligations. So this essentially means that a contract shouldn't necessarily be one-sided, where a person gets something for nothing in return. That is just something known as a gift. And so a contract involves the free exchange of obligations. This could be the exchange of goods for money in the case of purchasing something, the exchange for services, the exchange of services for goods, etc., 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 etc. Exchange for performance of some kind for money. So, i.e., doing some kind of service in return for money. These are all part of the exchange of obligations. Essentially, what the equality of obligations refers to is this idea that you are doing something for something else. And in contract theory, we can describe this as one of the foundational principles of the establishment of a contract, something known as consideration, or quid pro quo. The idea of you getting something in return for something, you getting something in return for you doing something. Not necessarily an equality of obligations. You don't need to be both doing the same amount of obligations per se. You can have a situation where one person does more for another, but you can still say that there is an exchange of obligations in that regard. So if you really wanted to, you could charge ridiculous sums of money for goods or services that you wish to sell. And that might not necessarily represent an equality of obligations, but it would represent an exchange of obligations, and as a result of which, that means that you fulfill that element of contractual theory. Now, in terms of the exchange of obligations, in classical contract theory, this is quite easy to work out when we look at bilateral contracts. When you look at a contract that is essentially a document, a piece of paper, or an oral agreement between two people, where they say, I will do this in return for this, you will do that in return for that. I'm offering that, you accept that. There is an exchange of obligations. There is an intention to create legal relations, and so as a result of which, you have a bilateral contract between the two parties. An exception to the exchange of obligations could be seen in unilateral contracts, at least at the initial outpoint at which the contract is made, or at least the offer is made, because the exchange of obligations is not necessarily present in the unilateral contract for the entirety of that process. Because what a unilateral contract is where you have one party that is going to be making a promise, that is going to be making an offer, and this offer is made public, and then it is up to another person to take up their obligations as part of that condition, and that represents the acceptance of that offer. So, for example, if I was to, let's say I was to lose a pet, for example, and I put those sort of lost, missing cat, missing dog signs up, and I say that there will be a £100 reward for anybody who finds that dog, my dog, or my cat, or whatever. that is representative of a unilateral contract, because what I've done there is made an offer to the public. I have offered £100 for anybody who finds my cat. So the specific performance of that contract, the performance of the individual who is going to read that particular contract and is going to take up their side of the obligations by doing what is essentially what I want them to do, which is to try and find my cat, I then therefore create a contract by way of the fact that the offer is made public and it is accepted by an individual who is going to then take up that side of the bargain. And that is what we get when we have a unilateral contract. It's seen as a relatively interesting exception within classical theory of contract, and we'll get onto unilateral contracts when we start to look at offering and acceptance and the formation of an agreement in more detail in future lessons' time.